like to talk about the legislation. We'd like to talk about Section 248.1 of the Income Tax Act, specifically 248.1c, which deals with experimental development. And of course, we've chosen to isolate or confine our discussion to 248.1c, primarily because most of the claims that are put forward are experimental development rather than basic research or applied research. Now, one of the issues that we have heard a lot about from taxpayers across Canada, as well as tax preparers, is there's a disparity in the viewpoint. And Justice Bowman, I'd like to ask for your opinion on this, but we're looking at 248.1 on the screen, and essentially what it's talking about is advancing technology for the purposes of creating new or improving existing materials, devices, products, and processes. But the key expression here that I would like to focus on and get your view on is what it really means by including incremental improvements there too. Could you comment on that, please?
I think the definition in 248.1 is, which includes incremental improvements, was there to fill a gap, or what was perceived as a gap in the legislation. In other words, the CRA was, I think, erroneously taking the position that if there was something already invented, but they were improving on it, that was not experimental scientific development. And I think in the definition that I had, I used the word infinitesimal improvements.
Yes, you did.
And I think that what I meant was to comment on incremental improvements there too. In other words, it didn't have to be a brand new product, it could just be an improved one.
Now, what's very interesting is oftentimes we see CRA denying claims because of the fact that they're taking a position that routine engineering was used, and oftentimes it's used in a way such as this, that known methods were used to resolve a problem. And the way that quantum tax law chooses to understand the legislation and also the case law that exists would perhaps not necessarily be in a restrictive matter, but would really like to have your opinion on this expression. This claim has been denied because known techniques were used to resolve the problem. Well, I would assert the following, that the term incremental not only means adding something small, but it also means adding something small to that which exists. Perhaps someone else's work, perhaps a body of knowledge on a specific area of science or technology. And to the extent that a taxpayer adds to a body of knowledge, which includes the use of arguably known practices or known techniques. My question to you, Chief Justice Bowman, would you say that the term incremental or incremental advancements there too, in this particular case, would you say that that would allow for an addition to a known technique?
Yes, definitely. I think the incremental implies that there be an addition or a minor improvement even. I can't imagine what known techniques would have been used by Thomas Edison when he invented the light bulb. And yet, no one would question that was a breakthrough experimental development.
Absolutely. Another thought is, if it's so that the use of known techniques to resolve an uncertainty are ineligible for SR&ED, one would argue that there may be no claims for microbiology in Canada if the use of a microscope, the use of a petri dish, or perhaps a technique of, say, adding a chromosome or altering a chromosome or adding a protein. Well, it might be that through observing an organism through the lens of a microscope, a scientist might come up with a cure for cancer, as an example. And if he used known techniques, such as, the method in which he, the tasks that he performed, and the method in which he analyzed it, but yet he advanced knowledge, would it not be eligible for SR&ED based upon the advancement of knowledge?
Yes, definitely.
So I think there's a certain disparity between taxpayers who are gaining knowledge, advancing knowledge, quite legitimately, where there's incremental improvements. And CRA is all too often, and by the way, there are good people in CRA and many of those as well. However, we do see a lot of situation in every jurisdiction across Canada where claims are being denied simply because of the fact that there's a failure to see the incremental portion. I would argue, and I would ask for your clarification on the following, Chief Justice Bowman, that if in fact you were not adding to a technique that exists or utilizing a known technique, then it wouldn't be incremental at all. I would argue that in the case that there was a forward advancement, one of groundbreaking nature, one that contained nothing but techniques that are unknown, well, that would not be an incremental improvement. I would argue that in order to be an incremental improvement, you'd have to be advancing or furthering techniques that are already known, techniques that are employed.
Are you asking me a question or are you making a statement?
I am doing both.
Well, tell me what you're doing, because I think that for there to be scientific research, it doesn't need to be necessarily using only routine methods.